Hi. Okay, so hello everyone. My name is Lisa Code. I am a lawyer with Strigberger Brown Armstrong Law Firm. We are a full service law firm and we practice in the area of insurance defense, both on the accident benefit side and tort side. We have 23 lawyers now and we practice out of 3 locations. That's Toronto, Kitchener-Waterloo, and London. I want to thank you for joining us today for Lunch and Learn. And before I get going, a little about myself. I am in my 15th year of practice, but the law is not my first career. I actually started in science, and I was one of those people in a lab using molecular biology techniques in heart and stroke research at the University of Waterloo. I then decided to go into law. Both are analytical type careers. And I've been practicing in the area of insurance defense ever since. I am on the tort side. I don't practice in accident benefits, and I enjoy practicing in all areas on the tort side. Primarily, I focus on personal injury, property damage, CGL, and segregated work. And I am one of the lawyers that practice out of the KW area. Now, I have a couple housekeeping issues to talk about before we get going. This presentation is being recorded for your future viewing pleasure, should you choose to do so, or if you want to refer at a later time. It'll be available on our website, and you can get the website on the slide before you. Also, or actually it's at the end, also the slides will be available. All you have to do is shoot me an email at lcode@sbalawyers.ca and I'll happily send you the slides so you don't have to take any notes. During the course of the presentation, if you have any questions, there should be a little button at the bottom of your screen for questions and answers, and we will have a session at the end, time permitting. If you have a question and we run out of time, I'll happily answer it by the end of today or tomorrow at the latest. Okay, so before we get into the thick of this, I am talking about vicarious liability, and vicarious liability has been defined in Black's Law Library as the imposition of liability on one person for the actionable conduct of another based solely on the relationship between the two persons. In other words, it's a situation where one party is held responsible for the unlawful conduct of another. Now, I am talking today about vicarious liability under the Highway Traffic Act and under the Ontario Automobile Policy. And in these sections, the applicable law is not in dispute. Under Section 192, subsection 2 of the Highway Traffic Act, and under Section 1.8.2 of OAP, there is no liability for loss or damage, and there is no insurance coverage where the operator is in possession of the vehicle without the owner's consent. Now, the key term there is consent to possession. That term comes from the wording of the sections themselves. I have the sections up. Section 192 of the Highway Traffic Act, subsection 2, states the owner of a motor vehicle or streetcar is liable for loss or damage sustained by any person by reason of negligence in the operation of a motor vehicle or streetcar on a highway, unless the motor vehicle or streetcar was without the owner's consent in possession of some person other than the owner or the owner's chauffeur. Now that wording I think is a little convoluted. A more plain English wording is found in the OAP section. That provides, except for certain accident benefits coverage, there is no coverage, including coverage for occupants, under the policy if the automobile is used or operated by a person in possession of the automobile without the owner's consent. Now, when will this situation come up? I've got a few examples. Of course, they're non-exhaustive, but Some of them are when an insured's child with a G1 license decides to take the family vehicle for a joyride, or when a roommate takes the insured's vehicle to run an errand without asking. Or, for example, when a friend or acquaintance, when you're at a party or a bar, takes the insured's keys and leaves with the vehicle, and say, for example, loses control of the vehicle and drives into a wall. I've actually had that file. In the alternative, you may be presented with a situation where the insured is hit by a vehicle that was taken under these types of scenarios. Now, why is it important? Well, it's all about money. Section 192 places on the owner of a vehicle liability for negligent actions of a person driving their vehicle. So the driver and the owner are typically named in the tort action. The policy then must respond to defend and indemnify the driver and owner. Now, if a vehicle is taken without consent to possession, then the owner is not liable for the driver's actions pursuant to Section 192(2) of the Highway Traffic Act. And the policy then does not respond to defend or indemnify the driver. In the alternative, if the insured is the one who's involved in an accident, and the at-fault vehicle is being driven by a person without consent to possession, then the insurer will be named in the tort action for a declaration that the uninsured motorist provision and the family protection endorsement coverage responds to pay the claim. Now, I'd like to move on to the case law. The seminal case about vicarious liability provisions of the Highway Traffic Act is Thompson versus Boissier, which is a 1933 Court of Appeal decision and has put into place the law that's been in place for almost 90 years. However, there was a twist that occurred some time ago in one of the Court of Appeals decisions and its interpretation of the word possession. I'm going to talk about that today, and it has been remedied. And now the modern governing authorities are Finlayson versus Gmec-Lesko and Fernandez versus Araju, which are Court of Appeal decisions that followed the Thompson decision. Now in Thompson, the facts are that Mr. Boissier rented a vehicle to Mr. Thompson. The rental contract stipulated that the vehicle was only to be operated by Mr. Lupson. Mr. Lupson then allowed another person, Mr. Brown, to drive the vehicle, and of course the plaintiff was injured while Mr. Brown was driving the vehicle. Now there are a lot more facts than that, but that's what it can be distilled down to. In rendering its decision, the Court of Appeal stated that the object of the legislation, which is now Section 192 of the Highway Traffic Act, was to protect the public by imposing on the owner of a motor vehicle the responsibility of careful management of that vehicle. And by careful management of that vehicle, they also wanted the owner to assume the risk of those the owner entrusted with the possession of the vehicle, that they observe the law. And if those that the owner entrusted possession of the vehicle did not, then the owner would be responsible for all loss and damage sustained in its operation. Now, in its decision, the court stated there was a clear distinction between the operation of a vehicle and the possession of a vehicle. It would be placing too narrow a construction on the word possession to hold that Mr. Lupson was not in possession of the vehicle when he was physically in the vehicle and Mr. Brown was driving it. The court held that Mr. Lupson, although not operating the vehicle, was still in possession of the vehicle with the owner's consent at the time the accident occurred, and therefore the owner was liable for the damages. In other words, the court found that the owner will be liable where the person to whom the owner entrusted possession of the vehicle is in possession of the vehicle at the time of the collision, even if the person is not actually driving at the time. The key principle that was enunciated in Thompson, and which is still cited to date, is that conditions placed by the owner on a person given consent to possession of a vehicle do not alter the person's possession of the vehicle. Now, as an example of how the courts have interpreted the term possession, I want to compare the Court of Appeals decision in Thorne versus Pretz. This is a 2003 decision and gives you an indication that decades later, the courts are still referring to the principle enunciated in Thompson. In Thorne versus Pretz, the owner gave Mr. Thorne possession of the car. Mr. Thorne then went out with Mr. McNeil. Mr. McNeil did not have a driver's license. And so Mr. Thorne expressly told Mr. McNeil that he could not drive the car. The two went out for a night of drinking at a bar, and Mr. Thorne passed out in the vehicle. Then Mr. Thorne woke up to find Mr. McNeil driving his vehicle and shouting a word of warning before the collision occurred. In this decision, the court held that Mr. Thorne was not in possession of the vehicle at the time that Mr. McNeil was driving because he was asleep. This case highlights the court's focus on the term possession. Here, although a person was given possession of the vehicle with the consent of the owner and was physically present in the vehicle at the time of the accident, they did not have actual possession of the vehicle because they were unconscious during the time it was being operated. Now, I mentioned there was a twist in history in the court's interpretation of the word possession. This happened back in 1953, where the Court of Appeal disturbed the principle announced in Thompson that conditions placed by the owner on the person given consent to possession of a vehicle do not affect that person's possession of the vehicle. Now, Newman has slightly different fact scenario than Thompson. It involves a situation where the owner has direct communication and contact with the driver of the vehicle at the time of the accident. In Newman, the owner gave consent to the driver to operate a farm vehicle on farm premises. However, the driver, who was an employee, was not allowed to take that vehicle off the farm premises and drive it on the highway. The driver then operated the vehicle on a highway for his own purposes and caused an accident. The Court of Appeal held that possession changed in this situation from rightful possession to wrongful possession. Or in other words, the court changed possession from possession with consent to possession without consent simply by the breach of the condition that the owner placed on the consent to possession to the driver. Therefore, the owner was found not liable as the driver did not have consent to possession at the time that the accident occurred. This decision is in direct conflict with the principle set out in Thompson, and it caused quite a bit of confusion in the court's interpretation of consent to possession over the years. I did mention it was remedied, but it wasn't remedied until 38 years later in 2015, when the Court of Appeal rendered its decision in Fernandez versus Arajou. In Fernandez versus Arajou, this is a similar fact scenario, and a 5-member panel of the court overturned the Newman decision as wrongfully decided, thereby restoring the general principle that conditions placed on an owner, by the owner on a person given consent to a vehicle do not affect the fact of the person's possession. Now, in overturning the decision, the Court of Appeal noted that most trial judges had distinguished Newman. However, those trial judges that had followed Newman showed that the Newman decision had sown the seeds of confusion over time, and therefore the court overruled it in the interests of clarity and coherence in the law. Despite this, though, it was decades that it was in place, and confusion has reared its head and continues to do so to date. The other modern governing authority on consent to possession is Finlayson versus GMAC Lesko. In this case, GMAC was the owner of a vehicle that was leased to Mr. Simon and Miss Jeffries jointly. The lease expressly prohibited Mr. Simon from operating the vehicle. In fact, there was an excluded driver endorsement on the policy for Mr. Simon. However, Mr. Simon was driving the vehicle when the accident occurred. The court held that GMAC was vicariously liable for Mr. Simon's negligence. In doing so, the court stated that GMAC had entered into the lease with Mr. Simon. The lease gave Mr. Simon possession of the vehicle because he was permitted to control its use, and therefore GMAC consented to Mr. Simon's possession of the vehicle. The court did acknowledge that GMAC did not consent to Mr. Simon's operation of the vehicle. However, the court identified that possession in law and operation in law are not the same. The court followed Thompson and noted that breach of conditions placed by the owner on another's possession of the vehicle do not alter the fact of the other's possession, and that includes situations where express conditions are put on the possession as to who may operate the vehicle. As an aside, the court also considered whether or not GMAC could contract out of Section 192 of the Highway Traffic Act, and noted that Ontario courts had consistently held that an owner's statutory liability enacted for the protection of the public cannot be ousted by the terms of an agreement to which the injured party, in this case the innocent plaintiff, was not a party. Now, the decisions that I have reviewed so far have dealt with express consent to possession, and that is direct communication of consent given by the owner to the person to whom the owner entrusts consent to possession of the vehicle to. However, the owner of the vehicle can also provide consent to possession by implication, and in those situations, there's no direct communication. The Supreme Court of Canada set out the test for determining implied consent to possession in Pileski versus Humphrey back in 1964. The test is whether all the circumstances were such that they showed that the person who was driving had the implied consent of the owner to possess the vehicle and was justified in thinking that they had such consent. Now, in decisions on whether or not implied consent to possession is being looked at, the court looks at all of the relevant circumstances, with no one particular fact itself being determinative of the issue. The court looks at the relationships between the parties and also the parties' course of conduct over time. These decisions are made on a case-by-case basis, and the court will look at indicia of implied consent as enunciated in past decisions. Some examples of indicia of implied consent are the driver's past use of the vehicle or any vehicle in the household, the owner's knowledge of the driver's past use, prior reprimand for breaking the rules, the accessibility of the keys or the vehicle or both, the driver's past behavior, untrustworthiness, bad conduct, alternatively good behavior, trustworthiness, and good conduct. Also, where the driver does not reside in the same household, how close the driver resided to that household, and whether or not the driver had access to the home. These are just some of many of the indicia that the court looks at. And over the years, the court has cast quite a broad net in its interpretation of implied consent to possession. presumably under the guise of the public policy concerns behind the legislation itself. Now, I want to talk about a more recent decision at the Superior Court level that was made in 2018 in Michaud Shields versus Go by Justice Dessau. This is a summary judgment motion that was brought by the plaintiff's uninsured motorist provider, seeking a declaration that the at-fault driver was given implied consent to possession of the vehicle being driven at the time, and also seeking a dismissal of the claim against it. Now, in this case, the driver was the owner's son, and the insurer was forwarding an argument focusing on the availability of the keys and the vehicle when the parents were away, arguing that the availability and accessibility of both basically invited the son to take the vehicle for a drive. In this case, the keys were hanging on a hook by the front door, and the vehicle was in the driveway. Now, in rendering its decision, the court looked at the relationship between the parties and the course of conduct between the parties over time. Some of the indicia of implied consent that were noted include the fact that the driver was the son of the owner, the driver was residing with the owner at the time, so the son was residing with the parents. At the time, the parents were on vacation, and the son's license had been suspended. The son had owned the vehicle for 6 years beforehand, but ownership had transferred to the mother 3 years before the accident took place. The court noted that while the son's license was suspended, he had not asked to use the vehicle. However, there were also no conversations had between the parents, or more particularly the mother and the son, about the use of the vehicle and whether or not it could be used. In terms of behavior, the court noted that the son had not taken any other items from the house or keys to other vehicles without permission. In this case, the son defended and provided evidence that he did not have his parents' consent to drive the vehicle. The son acknowledged that he should not have taken the vehicle and expressed regret for doing so. Justice Dessau did not accept the insurer's interpretation of the word consent. He found that it was far too broad and noted that the approach that they required to be taken would be that an owner would have to actively hide keys to a vehicle and presumably the vehicle in order to avoid liability. In finding the son did not have implied consent to possess the vehicle, Justice Dessau stated, the word consent within the context of the Highway Traffic Act means permission or authorization to possess the vehicle. It is a positive conferral of the right to possess a vehicle, understanding that the vehicle may be driven. Now, if there's a general understanding between the parties that the vehicle can be driven, then an express consent to possession doesn't need to be found in order to find liability. However, in determining implied consent to possession, to import a notion of liability on the basis of a lack of appropriate diligence to prevent use is to take the meaning of consent much too far. My take on this is that the court feared that the scope given to the interpretation by the courts on consent and possession had expanded, and there was a concern that even a scenario where a thief had stolen a vehicle, that the court would find implied consent to possession, presumably under the guise of forwarding the public policy concerns behind the legislation. Finally, the court noted that there must be an understanding between both the owner and the driver of the vehicle that the driver is authorized by the owner to use the vehicle. Now, I want to go through the points that I've touched on throughout the course of this presentation. One, the owner's vicarious liability is based on possession, not operation of a vehicle. Public policy considerations reinforcing the importance of maintaining this there are public policy considerations reinforcing the importance of maintaining this distinction, and that's protection of the public. The overriding principle set out in Thompson is that conditions placed by the owner on another person, given consent to possession of the vehicle, do not alter the fact of that person's possession of the vehicle. The owner is the one who has the onus of proving a vehicle is in the possession of another without their consent. The meaning of possession is a question of law. It is the application of that definition that is a question of fact and law. It's mixed, and it's to be made on a case-by-case basis. Consent to possession of a vehicle can be given either expressly or implicitly. The test for determining implied consent to possession is whether all the circumstances were such that they showed that the person who was driving had the implied consent of the owner to possess the vehicle at the time, and that they showed that the driver was justified in thinking that he or she had such consent. And in determining implied consent, the court will look at all of the relevant circumstances, including the relationship between the parties and their course of conduct over time, and will make its determination with a reference to the indicia of implied consent from previously decided cases. So this is the end of my presentation, and I want to thank you for spending time with me and listening to it. If you have any questions, now is the time for questions. And for any of those, just a reminder, for any of those who would like a copy of the slides from today's presentation, please just send me out an email to the email identified on your screen, and I will send them out to you. And I'm just looking to see if there's any questions. At this point, I don't see any, and we are very close to the end of the presentation. So before we get there, I'm just going to refer you to some upcoming presentations that I hope you join us for. On December 15th, Carolyn Meyer will be presenting Once Upon a Time, How to Tell a Compelling Story in Litigation. And Shalini Thomas will be presenting on January 20th, Damages for Mental Distress. Both, I'm sure, will be extremely interesting and informative. And I believe that nobody has questions for me here today. So I want to thank you again for joining me, and have a good rest of the day. Thank you.